Hi everyone, welcome to the Capital Litigation Improvement Project Series Jury Selection webinar. Thank you for being here today. As you might expect, several of our speakers are presenting remotely today from various locations, so please excuse any possible background noise you may hear. All of our participants, though, are in listen-only mode. So if you require audio via phone or have a technical question, please type it into the Q&A box on the right side of your screen. If you require closed captioning, please use the link on the welcome slide in front of you. As a note, we will be recording this webinar today, and presentation slides will be distributed to all attendees. So again, thank you all for being here and for joining. And without further ado, I will turn it over to Sasha Beatty from the Association of Prosecuting Attorneys to kick our presentation off today.
Thank you so much. Good afternoon, everyone. My name is Sasha Beatty, and I am Deputy General Counsel at Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., and we serve prosecutors as well as their law enforcement and community partners. Thank you for joining us at this capital litigation webinar today. This presentation is made possible by Grant 2018 CP-BX K002, awarded by the Office of Justice Programs through the Bureau of Justice Assistance Capital Case Litigation Initiative. APA is very appreciative of their financial assistance and commitment to improving the justice system. And additionally, a special thanks to BJA's National Training and Technical Assistance Center for providing the platform for today's webinar. Points of view or opinions in this presentation are those of the presenter and do not necessarily represent the views of the U.S. Department of Justice or the Association of Prosecuting Attorneys. Today's webinar, Capital Case Jury Selection, will be presented by Sheila Ross of the Prosecuting Attorneys Council of Georgia. Ms. Ross, an Atlanta native, serves as the Director of Capital Litigation for the Prosecuting Attorneys Council in Georgia. Career prosecutor, Ross previously served as the Managing Attorney of the Violent Offenders Unit of the Fulton County District Attorney's Office, a homicide prosecutor in San Francisco, California, and a prosecutor for the 4th Judicial Circuit in Jacksonville, Florida. She is licensed to practice law in Georgia, California, and Florida. In Ross's current assignment, she assists prosecutors statewide with murder and death penalty prosecutions. She also is a frequent instructor for law enforcement and prosecutors on murder, complex DNA, and legal insanity issues. And so with that, I will now turn it over to our presenter.
Hello, everyone. Hope you can all hear me and everyone is staying safe and healthy out there. I give you greetings from very dreary, rainy, overcast Atlanta today. We have about an hour today to discuss the mechanics of jury selection in capital cases. I'm not sure, especially because this is a webinar, exactly how many capital cases you all have selected or have tried. So I tried to make it a rather basic presentation and maybe a recap for some of you who haven't done this in a while. So with that, I'd like to start with something that should hopefully not depress you, but motivate you. But you, I'm sure, have noticed that there has been a nationwide decline in death verdicts all over our country. And this graph here basically lays out that the support for the death penalty presently is the lowest that it has been since 1972. So you all will have somewhat of an uphill battle, but it's not impossible. As you can see, there is a breakdown by region, with the South actually us having, I guess, an easier time overall than others in the rest of the country, but still the numbers are relatively right at half if you're in the East, 60% from the West, 63% in the South, and 62% support in the West. So the jurors' views on the death penalty, and that's one of the things you have to discover in your capital jury selection, and it's very different than a regular jury selection in a regular old murder case because you're actually talking punishment. And I think that's the main difference in selecting a capital jury versus selecting just a jury in a regular murder case. It is the number of people that you talk to and your discussion of penalty options. So the first thing I think you need to explore, and you will explore, is why. Why do jurors support the death penalty over some of the other penalty options? And what we have discovered here and some of the polling done on this is that the jurors that do express a support for the death penalty usually fall in along these lines. They think that the defendant deserves it. They are the what we call the old school or Old Testament jurors who believe in an eye for an eye. Some of them believe that it's more expensive to keep a defendant on death, or excuse me, in prison for the rest of his life. And so they decide on that issue, although that argument can be flipped the other way, and in just general deterrence. But regardless of these views, as we are here in Georgia, death sentences are now a rarity. So why is that? And we've spent a lot of time talking about that here, and I'm sure you all have in your respective jurisdictions if you've seen a decline. And that is basically in our state, LWOP has killed the death penalty. So in 2009, Georgia modified its statutory scheme to where a jury now has three options: life without parole, the death penalty, and life. And what we have noticed since that statutory change is a precipitous decline in jurors sentencing defendants to death. And so I think it's important to know in your state, whatever your options are, that when you are talking to your jurors, to talk to them about all the sentencing options and how they feel about them. One thing that we've discovered here is that some of the jurors favor life without parole. And it's interesting when you get, so in Atlanta, we would have about 500. We have to talk to about 500 citizens in order to get a death qualified jury here. And it's fascinating to talk to them about their feelings on life without parole. There are many, many people who believe that life without parole is actually a more inhumane sentence than the death penalty itself. So some of them feel like life without parole is worse than the death penalty, and that would be a better sentence in many respects than the death penalty. But many of them believe that it's just wrong to take a life. People may be wrongfully convicted, and I think we as prosecutors overall have, I think, done a decent job of self-correcting. I know, as I like to tell our younger prosecutors, that the death penalty day is not the death penalty that we had in Georgia even in the 1970s and 80s. In short, as they say, this is not your mama's death penalty down here. This is we are very we think about it differently. I think we're more reluctant to file the notices in our state than we've ever been before. And that is because of we know that our jurors feel that if there is residual doubt, if the person may be wrongfully convicted, not only that will that prohibit you from getting a death sentence, but it may also infect the guilt innocence phase of your trial. So we're always mindful of that. In Georgia, we have a bifurcated proceeding, and I'm sure almost everybody out there, thanks to Greg v. Georgia, which was our case here in the 1970s, everybody out there has a bifurcated proceeding. And so we are very cognizant of filing notices where there is residual doubt, because if there is residual doubt, you may find a jury that may not convict your defendant at all in the first phase of the trial. And then some jurors, just for punishment reasons, believe that it should be left to God and it's not for them to decide. So residual doubt, if the defendant has exhibited some positive behavior or some remorse, they're more likely to choose LWOP over death. Mitigation can be very powerful at times, which can influence their decision to seek LWOP over death. And also they reconsider their position when they're in the jury room and they're actually deciding what to do in the punishment phase. And a lot of times jurors will just decide on LWOP in order to avoid a hung jury on sentencing. And in our state, if it is not a unanimous death verdict, it is a hung jury and the judge will decide sentencing. And at that point, it's only LWOP and life as the options for the judge to consider. So reasons for deciding death over LWOP would be that the heinousness of the crime or the characteristics of the crime are such that they demand death over LWOP. Aggravation, especially if the defendant is a bad inmate, which in many states is called future dangerousness. And if the defendant shows no remorse. Those are the cases where our jurors tell us that they're more likely to impose the death penalty over life without parole. So going to what the main difference would be is you have to have a death qualified jury. And a death qualified jury is one that discusses and all the jurors qualify by saying that they can consider all of the sentencing options under your statutory scheme. So again, for us, it would be all jurors who could consider imposing the death penalty, who could consider imposing life without parole, and who could consider imposing life with the possibility of parole. That is what is a death qualified jury in our state and in your state as well. So I want to give you a basic legal framework for that. I described it very quickly, but here are the cases, the seminal cases that discuss what it is to be a death qualified jury and how you get there. I will say everybody, hopefully, if you've never done this before, you have to read these 4 cases that I have before you. Witherspoon, Witt is the other one is beneath it. We usually call it Witt, Lockhart, and the Brown decision. I won't read you the cites because you can read them for yourself. I will discuss in great detail Witherspoon and Witt. The other 2 I will not discuss in great detail, but will leave you to read them for yourselves. But they basically hold that, to death qualify a jury does not violate the 6th Amendment fair cross-section requirement, and that a trial court judge's decision on this matter is given great deference to the appellate courts or by the appellate courts. But the last bullet there, that is the court rules, and I should have had statutes in there, to forgive me, but it is statutes and cases in your jurisdiction on this topic. So in Georgia, we have uniform superior court rules, we have statutes, and we have a plethora of Georgia Supreme Court cases on this topic of death qualified jurors. I'm certain that many of you have the same, and it is incumbent upon you to pull those court rules, pull the statutes, pull the cases, and put them all in one big giant notebook with these 4 federal cases that I have for you, so that when you are in the courtroom, you will have them at your fingertips. I find the cases that actually give you the Q&A from the transcripts of voir dire itself are very helpful and instrumental to read, and it can help you frame some of these questions if you've never had to sit down and talk to 600, 500 citizens about how they feel about the death penalty. It's a daunting task, and if you can read the cases where they actually lay out the questions for you and the back and forth between the judge, the prosecutor, the defense attorney, and the juror, it will really help you frame these issues and get it clear in your mind. So I'm going to start talking about Witherspoon first. So to death qualify a jury, again, and there's a lot of literature out there for those of you who are brainy and like this topic and like academic pieces and social studies, sciences, and all kinds of polls. You could Google death qualification of jurors and find a ton of material to keep you busy at night. I used to love to do all those things, and I had kids, so I dropped about 20 IQ points. So I gave that up a while ago. But for those of you who really want to dig deep into this topic, please Google it, and you will have lots of things to keep you up at night. But Witherspoon, in short, is what kicks it all off. And the Witherspoon test, which you can see here, is jurors who cannot under any circumstances consider the death penalty are excused for cause from jury service. And then you have to put Witherspoon in context, and the federal courts are quick to do that in all the years that followed after 1968 when Witherspoon was brought up. And when you read Witherspoon, you will see that this is an exact quote from the trial judge. This was a Cook County, Illinois case, and for those of you now know, Illinois doesn't even have a death penalty anymore. This is how long ago this was. And this is what the judge said on the record. Quote, "Let's get these conscientious objectors out of the way without wasting any time on them. And when the judge was referring to the conscientious objectors, he was talking about people who are conscientiously opposed to capital punishment. So what happened after that is in rapid succession, 47 out of the 96 prospective jurors were dismissed for cause, based solely on the fact that they were opposed to capital punishment without much digging beyond that. If the juror answered that they are conscientiously opposed to capital punishment, they were excused for cause. And from that fact pattern, the Witherspoon test was born. So you need to know that before you even start to dig into what Witherspoon means. But it does mean that jurors who say to you, not, under no circumstances, whether it's Hitler, whether it's Charles Manson, whether they kill their own child, under no circumstances, if a juror cannot consider the death penalty, they are excused for cause from jury service. Witherspoon has been upheld many times by our Supreme Courts and our federal court. Shall say our Supreme Court, being the U.S. Supreme Court. It's also been upheld by the Georgia Supreme Court. I'm certain that in your states it's been challenged as well. But the Georgia Supreme Court has held that the Georgia Constitution at times can exceed what is promised by the U.S. Constitution. So we have to worry both about the Georgia Constitution and the U.S. Constitution here. I'm certain many of you have that same paradigm in your state, so just be mindful of what your Supreme Court has said about Witherspoon. And so there is an inverse Witherspoon consideration, and that is jurors who would automatically vote for death. That is, they would not consider life without parole, they would not consider life with the possibility of parole, but they would automatically go to a death sentence, are also ineligible for service. So you will hear many defense attorneys and sometimes courts refer to that as the reverse Witherspoon objection. So now that you understand Witherspoon, you need to know that Witherspoon was later clarified by our Supreme Court in 1985 in the Witt decision. And this is it's a Florida case, and they lay out Witherspoon and talk about how it's been difficult for federal courts to interpret it. And so they created this standard, or pronounced this standard very clearly for all of us to follow in Witt. And here is now the standard, which is whether a juror's views would prevent or substantially impair the performance of his duties as a juror in accordance with his instructions and his oath. Crystal clear, right? It's that's the standard, and that's what you say over and over again many times for however many weeks it takes you to pick a capital jury or to make a death qualified jury in your jurisdiction. And there's an interesting twist on Witt, and you need to think about it in a bifurcated proceeding, and that is whether the jurors' views on capital punishment would prevent them from performing their oath in the guilt innocence phase, meaning would their views on the death penalty impair them in deciding guilt innocence? And there's that first phase consideration, but it's also a second phase consideration. Would their views on the death penalty impair their performance in the sentencing phase of the trial? So it's both. It's applicable to both phases of the trial. And so that is the ultimate question, and that's the question that gets asked over and over again in a capital jury selection. And I'm going to talk about twists and turns on that a little deeper in my presentation when I discuss specific questions and specific roadblocks you have in trying to determine whether a juror is substantially impaired by their views on capital punishment. On a side note, if any of you have not read this book, I highly recommend it. I did not know, and for many, many years, I picked capital juries, and I read Witt, and I read all the federal cases and state cases that interpreted Witt. And if you read Witt, you will read that the facts of the case are that a 11-year-old boy who was riding his bicycle to the store was met by two defendants who murdered him, tortured him, sexually mutilated him. But nowhere in the Witt decision itself do they ever mention that child's name. You just hear that he's an 11-year-old boy. So I saw this book a few years ago, and I read it, and it's written by John Kushner's brother. So the victim in the Witt case is John Kushner. He was 11 years old. He lived near Tampa, Florida at the time of his murder. His brother David was 4 years old at the time of his murder, and he wrote a book about his brother's murder, and they mentioned the Witt decision in it, and it's just very compelling. And I felt guilty having talked about Witt for so many years in my career and really having no idea the true compelling story behind the decision. And I think we as prosecutors, many times we lose touch with what we're really doing. So I just encourage you all, while you're reading all those studies on death qualifying juries and what it means to be a death qualified jury, also read this book, and it will get you in touch with why we still have the death penalty, and what the Witt decision was all about. It gives you a historical perspective. So with that, I'm going to move on to our statutory question. I'm certain that you all have a statutory question, so find it. Here's ours. As you can see, our legislature hates us. They never want us to get the death penalty. This is why this is our question. Are you conscientiously opposed to capital punishment? That is the question we are required to ask under Georgia statutes. Put that question to 500 citizens. Half of them think you're asking, do you not like Washington, D.C.? There's just so many things that people get out of you asking that question. What very few of them realize is what you really are asking them is, how do you feel about the death penalty? Which is a much better way of asking that question. So I, in my capital selection, jury selection cases, yes, we must ask the statutory question. As I told you, we have court rules here that dictate how it's asked. So a judge in Georgia has to ask that terrible question about whether they like Washington, D.C. or not. But when it's my turn to ask questions, and when I use a jury questionnaire, and we're going to talk about that, I use a written questionnaire in capital cases. That's how I ask it. How do you feel about the death penalty? And from there, that's our kicking off part. That's our starting point. And from there, we deep dive. As I told you before, and you should find the case law in your jurisdiction, but to be a death qualified juror in our state, you must be able to consider all three sentencing options. So make sure you gather those case laws. It's not just the death penalty, it's LWOP and life with the possibility of parole. And as we get deeper into it, you'll see many times life with the possibility of parole can be a bigger hurdle for most jurors than the death penalty when it comes to some of these cases. So how do you prepare for this? You must prepare for this, and you must prepare a system. Work with your court. Sometimes we have such new judges here in Georgia. We have many judges on the bench who have never selected a capital jury. And if you're in that situation, you've got to talk to your judge and defense counsel pre-trial about how you're going to handle it. It can take weeks. It has taken me personally anywhere between 3 to 12 weeks to get a capital jury in Atlanta. And we have talked to usually it takes us about 500 to 600 citizens to get 42 death qualified jurors in our jurisdiction. Some jurisdictions vary. I even know in Georgia, I've heard judges say we can get a death jury in 2 weeks. I've heard one say we can get it in a week, and I was fascinated to see how that could be done. So I know it varies wildly from jurisdiction to jurisdiction. So just be sure that you know what the rules are in your jurisdiction before you commence this process. Discuss it pre-trial. And when I say discuss how it will be handled mechanically, sometimes, especially if you use a written questionnaire, we bring all 500 people in on day one, and then we bring them back in panels of 12 over a 2 to 3 week period. And that's how we handle it. But talk to your judge about how he wants to handle it, or how she wants to handle it. Also, I like to file motions ahead of time, or at least discuss ahead of time the format and the parameters of the Witherspoon questions. That also limits, in my opinion, and cuts down on some of the foolishness, for lack of a better term, that the defense counsel likes to engage in the full ramification and scope of the Witherspoon questions. So make sure you have a discussion of that. I know a lot of jurisdictions just have pretrial motions they file ahead of time saying, hey, look, judge, this is Witherspoon, this is Witt, here are our court rules, here are our statutes, here are the questions that are permissible, here are the questions that are not permissible. We want to get a pretrial ruling from you, judge, before we start talking to jurors about what we're going to be allowed to ask and what we're not going to be allowed to ask. I create a grid and a cheat sheet on each potential juror where they're ranked. And if you're doing this alone, that's kind of easy. You can have your own ranking system. If you're doing this with co-counsel, I think you need to get together on what your ranking system is. I rank my jurors 1 to 5 for guilt innocence and 1 to 5 in sentencing. So they do get a different rating based on sentencing and guilt innocence. And I have a one sheet that I have per juror that I put in front of my questionnaire that when I'm talking to the jurors, I'm able to rank them. I rank them every night before I go home and while I see them, because again, this is a process that you could see a juror on day one, and then you don't see that juror again until 10 weeks later when you're striking the panel. So make sure you have some kind of grid or cheat sheet, and you can even do this electronically. There are all kinds of apps out there now for jury selection that you can use just so that you can keep good notes on each juror. I even use a notebook for each juror, again, with my written questionnaire, my handwritten notes from their responses, and my ratings all in one place on each juror. So whatever it is for you to get organized, do that. So along with your notebook on the jurors, you're going to need a notebook on the law, compiling all those things we've already discussed in either an electronic format that you can search in one folder, or the old-fashioned way, as my IT person just told me when they saw my printed out voir dire notebook, 10-4 dinosaur. Yes, she just said that, which made me laugh, and that's why I'm laughing again. 10-4 dinosaur. If you want to print it out, go right ahead and be a dinosaur, but you have got to find a way where you can put your hands on it fast. If you are in a courtroom in a rural part of our state, even with a hotspot, Wi-Fi can fail you. So I will gladly 10-4 dinosaur all day long so that my Wi-Fi does not fail me and I can put my hands on documents when I need to do so, because I have been in a courtroom where my Wi-Fi has failed, and I never want to be in that position ever again, especially in a death penalty case where it is so important that we get things right. So do whatever it takes to have the law at your fingertips, and do not be afraid to 10-4 dinosaur. So for jury selection itself, I said this before, I'll say it again. Use a written questionnaire. If you do not have one, get one from someone who has done this before. If you are in a state where you can't find anyone who has ever done one before in your state, email me or message me, and I will send you one of the ones that I have used before. But I like a written questionnaire. I kind of consider it a street level IQ test as well, because you get to see how people write. It's also done silently. So you get different responses than when you have 500 people in the room and they're telling you in front of 500 other people how they feel about the death penalty. If you ask them how they feel about the death penalty in a written questionnaire, I think you get more thoughtful responses and more honest responses, because they think it's only going to be read by the attorneys and the judge, and that's true in our jurisdiction. We don't share them with other people. And so you just get a better, more honest answer, I think, when you use a written questionnaire. But a written questionnaire is not a substitute for a voir dire, and so we use a written questionnaire, and then we bring them back individually to conduct individual voir dire. Conduct social media searches. I'm sure y'all doing that now on just a normal murder case or normal regular case, but it's critical to do in these types of cases. Does your court reporter produce daily transcripts? If they don't, you're going to need one that does, or use 2 court reporters so that you can get daily transcripts so that your judge can make informed decisions on Witherspoon challenges for cause. This is not the time to be guessing with your handwritten notes about how a particular juror responded to a question, you need the transcript. And so if your court reporter can produce daily transcripts the very next morning in court, your judge can read specifically what the juror answered and then make an informed decision, which according to the Supreme Court in the Brown decision that I gave y'all early on in my, let's see, the 11th slide, the trial court is given extreme deference in their rulings on challenges for cause. So give your trial court everything they need to make an informed decision and get daily transcripts. And then also, of course, take great notes. And this usually does require either two attorneys or an intern or an assistant that can help you take notes. Because even if you're writing notes by yourself, more important than what they say is how they say it. And so you need to be able to observe your juror's demeanor and make a record of it if helpful. And I should have said if appropriate. And experienced trial lawyers, y'all know how to do that. If you see a juror crying, clearly you say, Mr. Juror, I see that you are crying. Let's talk about that. If you see a juror shaking their head no, when you get up to talk to them, you know, Mrs. Juror number 47, I observed that you shook your head no. So whatever demeanor you are observing, it is critical that you put it on the record. And if your head is down and you're taking notes and there's no one watching for you, you're going to miss all of that demeanor. So whatever it takes to get at least two of you in a courtroom, and I know lots of people don't have resources to do that, but even if it's your paralegal, your investigator, your intern, get two of you in there so one of you can write and another one of you can look. So you do need to, unlike a regular murder case, evaluate your jurors' life experiences with anticipated mitigation evidence. Now, I don't know how your discovery statutes are, but ours pretty much, again, our legislature hates us. They want us to lose. So we don't get mitigation technically until after a guilty verdict is rendered, which gives us zero time to process it and fight it. However, if you have done a thorough investigation, and hopefully we are all doing thorough investigations before we drop a death notice these days, you've probably got a good idea of what mitigation is coming your way. I know that I think there are like 13 of you listening, so all 13 of you would say intellectual disability. All 13 of you would say my defendant was abused as a child. All 13 of you might say my defendant was sexually abused as a child. And by the way, never underestimate the Disney movie Bad Mother. Everybody loves to blame the mother. So you know what mitigation generally is because you've been around. You know what specific mitigation is going to be relevant in your defendant's case because you hopefully have done a very thorough investigation prior to filing your notice. So with that, when you are examining your jurors and death qualifying them, think about their personal experiences. Ask them, these are questions that should be in there. You know, do they have family or friends who suffer from mental illness, disorder, intellectual disabilities? Get a clear picture of their experiences with all of those things. Substance abuse is always a mitigator that we see here. So ask, how many of you have friends or family members who have past experiences with substance abuse problems? And then look out for jurors who might be sympathetic towards mitigation while you are selecting your jury. So it's a little different than a regular murder case. Spiritual and religious views are always hot topics here. More often than not, it is the defense attorneys diving very deeply into the jurors' religious beliefs. It may be something you choose to ask as well. I tend to ask it only in the sense of, do you have strong religious beliefs that impair your ability? Some defense attorneys like to go deeper into exactly, well, what does your church preach? Are you Old Testament? Are you New Testament? I find that those get really, I like to let the defense do that because they get really personal, and then they start offending the jurors, and now the jury's pissed off at them, and I'd rather them be mad at them than me. I ask it in a way where I am comfortable that there are no religious or spiritual views that will impair this juror's ability to consider all three sentencing options, and I tend to leave it alone, and then I just sit back and watch them blow up. I don't know if your experience is different in that regard, but if you are asking about it, I would be very sensitive about it. People don't like being pushed and poked like that in court, and with specifics about their parish and their minister. So tread lightly. If they're doing it for you, just sit back and watch them blow up. But ask the question where you're comfortable that it's not going to interfere, but I wouldn't go beyond that. So be prepared for jurors to shift their positions and equivocate in this process. If you haven't realized this by now, you need to know we are not normal people. Prosecutors, specifically homicide prosecutors, we are messed up. We are not right in the mind. We've seen way too many bad things. We think about way too many bad things all the time, and we're just not normal people. Normal people, this may be a shock to you all, normal people do not go around thinking about the death penalty. And many times, the first time that they have ever thought about the death penalty is when they're looking at that questionnaire where you have hopefully asked them in a way that they understand what you're asking, how do you feel about the death penalty? So usually a sign of equivocation for me in jury selection is a sign that either the juror is not being honest with me or they're really just kind of stupid, none of which I want out of a jury. But in this particular situation, I would say that you're going to need to be a little patient with people, and I wouldn't write off a juror who equivocates. And you need to be prepared for them to equivocate. You need to be as prepared for them to equivocate as you are prepared for your gang members to recant on the witness stand. That is how prepared you need to be, because it's going to happen. So I call it waffleitis. It happens so much. They have waffles for breakfast. They don't know if they're coming or going. They like the death penalty. They love the death penalty. They hate the death penalty. They could do it. They could never do it. Life without parole is okay. No, life without parole is better. No, it's not better. That's what they do. So when you have a juror who is that way, and you're gonna get waffleitis, you're gonna see waffleitis. There's gonna be waffles all in the courtroom. I want you to hear this song in the back of your head. So we're gonna play it for a little while. One, because we all just need a really good music right now in our lives. And two, I want you to remember this, because when you are in that courtroom and when you got waffles, this is what you need to be thinking. Here we go. Okay, that's enough. It's a great song. Slow it down. That's my way of saying slow it down. Apparently, I talk fast, especially for someone from the South. My court reporters and I all have that code where they clear their throat and I slow down. I am constantly moving fast. I got 60 things to do. I'm thinking about the 60 witnesses that I have, on 2-hour call. I'm thinking about the 500 jurors that we got to talk to today. And I just want to get through and power through jury selection. If that is your mindset, when you got waffles in your courtroom, you've got big problems. One, you're going to run over a juror and not really understand how they feel. And two, you're going to make a sloppy, bad record. And if you erroneously exclude just one of your jurors, you could be doing this all over again, and no one wants to do that. So slow it down. So first of all, you're going to slow it down. That's your first thing to do with waffleitis. The second thing you're going to do is stop being a lawyer. Hard to do, but you're just going to stop being a lawyer. And you're going to have to channel your inner Oprah or your Dr. Phil, whatever your jam is. I prefer Oprah. And you're going to start talking to them like people. And you got to ease into the questions. Your first question should not be, okay, ma'am, I understand that you feel that way. Does that substantially impair your abilities as a juror? No, 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 no. No, no, that's not going to get you what you want. You got to slow down and ease into it. So it's, how do you feel? How long have you felt that way? How strongly do you hold that belief? We'll go over some of those questions. Make a good record, because as we say, records are not just for Motown. Records are important. And urge your judge to make those credibility and the demeanor determinations on the record. Because if you're just reading the black and white images, which is what our appellate courts do, and your judge doesn't put in there, or you don't put in there, that juror was crying, this juror was very emotional, you're likely to get reversed on appeal. So make sure that you're making those determinations or those observations on the record, and that your judge is doing the same. And your judge can say, and has the authority to say, I understand that this juror said that she could eventually consider capital punishment or could eventually consider the death penalty, but I am making a finding of fact on the record based on the totality of the juror's answers and the fact that the juror was crying, that she's not being honest when she says that. So make sure that those determinations are being made. Don't leave anything behind. Don't leave anything on the dance floor. Don't leave any crying behind. Don't leave any head nodding behind. Don't leave any sighing behind. All of those things are really important to capture for the record. So here are your key phrases into easing into the questions. It is, is this a fixed opinion? Now, you don't have to start with, is it a fixed opinion? You start with, how long have you felt this way? How strongly do you believe this? Is this a religious belief? Is this a moral belief? If it's a religious belief, how long have you been Catholic? How long have you been taught that way? What does it mean in the Catholic Church that if you do impose the death penalty, have you expressed this belief to others? If so, how often, when, and to whom? Because if they're talking to their mama about it, it might actually be a strongly held belief. If they're just kicking it around at a bar, it may not be. So in order to get to the bottom of how they truly feel about things, you cannot be a lawyer. You just have to stop being a lawyer for that moment. So for framing the sentencing option questions, and I'll talk about this a little bit more too when we get into what you can anticipate from the defense. The trick seems to be from the other side to get the jurors disqualified on the either reverse Witherspoon questions or their failure to be able to consider life with the possibility of parole. And I'll show you a little more of their techniques. But when it comes to actually questioning a juror on how they would impose a sentence, it's very confusing to them because they haven't heard anything yet. They haven't heard any evidence yet. They haven't even found the defendant guilty yet. So they're in this stage of the trial where he's presumed innocent or she's presumed innocent. So it's very confusing to them, these rapid fire questions from these lawyers about how they feel about sentencing. So I have found it very helpful, especially if it's a juror you want to keep, to start with this. And if you get to go first, hopefully you do get to go first as the state. Not all the time do you get to go first. But if you get to go first, it's very important to frame all the sentencing option questions with the following. Nobody is asking you how you would vote today. So nobody is asking you right now if you would impose the death penalty, if you would impose LWOP, if you would impose life with the possibility of parole, because you haven't heard any evidence. And anyone who's asking you what you would do today, that would be an unfair question. That is an unfair question because you haven't heard anything. If you can phrase the questions like that in the beginning, your jurors get an idea of where you're going. And they understand, okay, you're not asking me would I impose death right now having heard nothing. And you're not asking me would I favor LWOP or would I favor life without parole. And by the way, they can have a leaning. They can lean towards death. They can lean towards LWOP and still be qualified jurors. They can lean towards life with the possibility of parole. They can have a leaning all day long and still be qualified. What they can't be is they can't automatically reject any of the sentencing options and be qualified. So what we need today, what we need to know today, having heard no evidence, is there a sentencing option that you would not even consider? Would you not even consider the death penalty? Would you not even consider life without parole? Would you not even consider life with the possibility of parole, sitting here right now having heard no evidence? If you frame it for them in that way, you get more honest answers and you get more informed answers. And it can help you save a lot of jurors who would be lost either on life or death, because that's really the extremes is where you lose them. You don't lose very many people on life on LWOP. It's people saying, I can't consider the death penalty, and people saying, I can't consider life with the possibility of parole is where you lose them. So how do you rehabilitate some of these people? These are questions that I use all the time in normal trials, and I also use them in capital trials. And the first one, I have never had a juror say no to in a room full of people. Do you consider yourself a fair person? Back it up. You know, are you the type of person who's going to sentence someone to death right now, not having heard the first piece of evidence? Because really, if they are that type of person, you don't want them in your jury room anyway, because they are going to alienate other jurors. And one of the things I like to sit back and think for every jury selection is this a person that I would like to deliberate with? And if the answer is no, they need to keep stepping, even if they're for you. I always say they could be crazy for you and they could still be bad jurors. They could be the most pro-state, pro-death jurors you've ever seen in your life, and they're going to be bad jurors because nobody likes them. They're going to get back into the jury room, alienate all of your jurors, and then you're going to have a hung jury. So make sure you are picking reasonable, nice people that can get along with others, because this is a group dynamic. In the regular jury, and especially in a capital case, it is unanimity in our state. If all 12 jurors don't sign off on death as the sentence, you don't get the death penalty. So make sure you are picking people who are fair and who are open-minded. Have you already made up your mind without hearing the first piece of evidence? If the answer to that question is yes, they need to get off your jury and keep stepping. Are you open to considering the evidence of mitigation, or have you already made up your mind to reject it? If again they say, no, I'm not open to considering anything, I've already made up my mind, this guy needs to die, they need to go. Not only do they need to go because constitutionally they're probably not going to be permitted to sit, but they need to go because they're jerks and no one's going to want to deliberate with them. So what else do you want to know? In Georgia, we have a broad statute that allows us that is broader than the United States Constitution, that allows both sides to ask about critical facts in death penalty cases. Well, in all cases, but especially death penalty cases. And if anyone is here from Georgia, y'all know what I'm talking about. It's Ellington, and it's 15-12-133 is our statute. I don't know if your state has similar ones, but if they do, there are other critical facts in a death penalty case that may influence sentencing that either side might be able to shop in front of a jury. Some states don't permit it at all because that's prejudging the case. Some states allow you to do it. So just know where you're at. And if you're in a state that allows you to do it, know that multiple victims, child victims, heinous facts, horrible defendants, people who are horrible human beings, statutory aggravators, and mitigation are all things that may be fair game in a death penalty voir dire. So what can you anticipate from the defense? Well, a lot. Colorado method of capital voir dire. If you all have not heard this yet, you need to Google it and spend a lot of time reading it. There's, again, lots of literature out there, but they've got a game plan. And this, in short, is their game plan. In these words, pro-death and life-giving, these are their words that they use. But basically to them, you know, while we play the balancing between guilt, innocence, and sentencing, because if you don't get past the guilt innocence phase, you're not going to have a sentencing trial. To them, the end game is all sentencing. The end game is saving their client's life, and all of their questions and all of their strikes are dedicated to that goal. They do what they can, whatever they can, to get jurors off for cause. They want all pro-death jurors removed for cause. How do they do that? They get them on the life with the possibility of parole. They get them to say, and I'll transition to the next slide. They get them to say the following. I want you to assume the defendant has been found guilty of the most heinous crime you've ever heard of. It's an intentional murder. It's premeditated. It's cold-blooded. Use whatever word you want to use. There's no self-defense. There's no justification. It's not an accident. There's no mental health. There's no excuses for it. It's basically just a senseless murder. How you feel about the death penalty now? Yes, that is what they do. They completely, they take out all mitigation, and they just say, I want you to assume that my client is the worst person on the face of the planet who has killed people senselessly with no justification, has no reason to do it, just did it for fun, and then he also killed a few puppies while he was at it. Could you consider life with the possibility of parole for that person? And if the answer to that question is no, your juror is going to be shot for cause, not shot, sorry, that's the wrong word, excused for cause, because they're unable to consider one of the sentencing options. So you see their trick. It's they conveniently they leave out mitigation. And the relevant issue is not how they feel at that moment about the death penalty. The relevant issue is going into the second phase of the trial, can they consider mitigation and can they consider all of the options of sentencing? That's why I think it's so important to go back, and when you go first, if you get to go first and you frame all of your questions with sentencing, nobody's asking you how you would vote today. That is an unfair question. Anyone who would ask you right now, having heard no evidence, how you would vote, that is unfair. Since the defense is being unfair to you, what we need to know is, can you consider all three options? Can you consider mitigation? You will bypass a lot of this. And once they get up and do all that, they'll be ready to say, well, are you asking me how I'd vote today? Because that's not what I heard the state say. I mean, is that what you're asking? Because I can't answer that. I can't tell you how to vote because I hadn't heard anything. Hopefully, they'll be able to answer those questions appropriately. Hopefully your judge will shut down some of those questions. But a lot of times you can't count on your judge to do that because they don't want to shut them down on anything on death penalty cases. Also, a lot of times they isolate the jurors, and they have had them tell jurors that deliberating is synonymous to bullying. Yes, indeed they do. So you need to be prepared for these types of questions. What they're doing is priming the jurors through this Colorado method, that if they are on the jury, they're priming you and them for a hung jury in sentencing. They're encouraging the jurors to stand their ground. They're preferencing any kind of deliberation as bullying. They're saying that if you feel strongly about life, you should not give in to the others. So be ready for those tactics and be able to combat them. There are objectionable questions. I would ask that you find those cases in your jurisdiction and do a memo to your judge. You can't ask jurors in our jurisdiction how they would weigh certain mitigation. Of course, that's very different than whether they can consider mitigation. You can't ask jurors what type of mitigation they find compelling. You cannot ask them in our jurisdiction about the mechanics of execution or the mechanics of parole. So make sure that you pull all those cases out there that talk about the questions that they can and cannot ask. You also need to know that in a capital case, this is not a sprint, it is a marathon. People will be talking about the questions you asked, the things that you did 40 years from now. They will. When you are long gone and hopefully retired and having fun somewhere, they will still be talking about this case. You need to know that in jury selection, and you need to choose wisely. I have this Georgia case up here for a reason, and this was a case that was decided back in 2018, where many years after the verdict, the defense went to the jurors who sat on the case and got an affidavit from an elderly juror who expressed racist views, and that was a reason for the Supreme Court to send the case back to the 11th Circuit. And I don't have time to really roll through the rest of this, but you could see it. And the takeaway from that is never, ever, ever block or impede the defendant's attempt to explore racial bias and our racial attitudes in jury selection. And that can go for anything that they're entitled to ask about in jury selection. Just don't stop it. Like, we all need to know, as long as they're asking the questions fairly and appropriately, we all need to know how these jurors feel up front about these very important issues, because 20 years from now, somebody is going to show up at their door with an affidavit and ask them to sign it. So just get it out. We all need to know now. No one is benefited by blocking any types of questions about things that they are entitled to ask in jury selection. I was asked to leave a few minutes for questions, and I have done so. And I will leave you with this cartoon. This is kind of how I feel sometimes, that we do all these things and we're so careful and we're so thoughtful in jury selection. And then afterwards, after you get your verdict and you go back and talk to the jury and they want to talk about your shoes or your accent or things, and you're just terrified for democracy. But those are only moments of lapsing judgment. And then I get back behind why we're here and why we do the things that we do. So it is very important to ask these questions. It's important to know the law. It's important to remember all the things that I'm talking about today, but just sometimes we do feel disheartened by our work. And so I like to laugh about it with silly cartoons. So with that, I am told to leave the floor open for any questions that you all may have.
Thank you very much, Ms. Ross, for that presentation, and thank you to everybody who joined. We do have some time to answer any questions, so if you have a question for our presenter today, please type it into the Q&A box on the right-hand side of the screen. We will read it out loud. However, all participants will remain in listening-only mode. So we'll give everybody a few minutes to submit their questions. All right, so we do have one question. You mentioned in your presentation the importance of recording the rehabilitation of jurors. Are there other issues or points in capital case voir dire where we should be particularly careful and ensure we are protecting the record?
The short answer to that question is yes. Everything has to be on the record in a capital case. And I would say from experience, the quickest way to get in trouble with that is that sometimes you start court back up again and you look around and the court reporter isn't there. A lot of times the judges do that for you, but in a capital case, I mean, you've got to do your job. You have to do the judge's job, and you have to do the defense attorney's job if you want your conviction to withstand the scrutiny that it will undergo on appeal. So yeah, everything, no bench conferences, no ex parte, no nothing. Everything must be on the record in a capital case. And if there is ex parte between the court and the defense, which is permitted, make sure that that is done on the record as well. You won't be there, but you'll have to say, hey, I know I won't be there, but make sure that there's a court reporter with y'all when you ex parte.
Thank you very much. It doesn't look like we have any additional questions at this time, but if you were unable to get to your question or you think of it later, please do not hesitate to contact us at the email address on the screen, bjantac@ojp.usdoj.gov, and we will be sure to address it. I'd like to say thank you to both Sasha and Sheila, our presenters, and thank you to our attendees. We will be sending a follow-up email with a copy of the slides. And we'd also ask that when you exit, you take a few minutes to answer the survey that you'll be redirected to. It helps us as we plan future webinars. So again, thank you all for joining us and enjoy the rest of your afternoon.